Good afternoon. Thanks to everyone for joining and welcome to today's webinar, H-1B Planning, Current Trends and What to Expect This CAP Season, presented by BAL. During the presentation, all participants will be in listen-only mode. If you have a question during the presentation, you may submit it at any time via the Q&A button located in the menu bar on the right side of your screen. Simply navigate to the Q&A section, click the Ask a Question button, and type your question into the window and hit Submit. We will also be polling the audience during the webinar. When the poll is opened, it will appear on your screen. You will have a minute or so to review the question and submit your answer. An email containing a link to the slides and on-demand recording of this session will go out tomorrow within 24 hours of the webinar start time. And finally, at the end of the webinar, we would appreciate you letting us know how we did via the survey section on the right of your screen. We really value your feedback as it shapes how we provide you with updates that are most relevant to you. And now it is my pleasure to introduce you to today's speakers. Michelle Funk is a partner in BAL's Tyson's office. She is adept at simplifying complex processes for companies and their foreign national employees with a focus on H-1B visas and PERM programs. Michelle understands the significance of H-1B visas to clients' business objectives and develops creative strategies to help them meet their goals. Heather O is a senior associate in our New York office. She works closely with clients in diverse industries to ensure their H-1B programs run smoothly. She also advises on immigration compliance, program management, and corporate reorganizations. Stephanie Pimentel is a senior associate in our Dallas office. She advises companies on planning and executing immigration strategies to meet their talent needs. She assists them throughout the H-1B CAP season and beyond. And now I will turn things over to Michelle.
Thank you so much, and thank you to everyone for being with us today. As we were preparing for the panel, Stephanie, Heather, and I realized that combined, we have a number of years of experience in managing H-1B CAP seasons. And as we thought through the process, we realized that no CAP season has been precisely the same. While each season follows a particular flow or format, the specifics in terms of timelines and acceptance rates can vary widely, and it can be very hard to predict. Our CAP seasons are impacted by how well our economy is or maybe is not doing, by pent-up demand from prior CAP seasons, and by global issues beyond anyone's control, such as a pandemic. Each season is also impacted by USCIS policy updates, including complex changes through wide-reaching policy memos, and more simple yet equally impactful changes such as last-minute changes in whether or not premium processing will be available. Because there are so many factors at play, it's important for us as practitioners to keep abreast of those kinds of changes and events to see if we can make any educated guesses about what may happen the next time CAP season rolls around. Today, while we're with you, we'll take a look at what we can expect during the upcoming CAP season. We'll talk a little bit about CAP planning and resourcing, and we'll also take a look back at how the CAP season has unfolded in prior years to try to gain any insights we can that may help us navigate through the upcoming year. With that, Heather, I will turn it over to you.
Thank you very much. So we've just heard Michelle lay a little bit of the groundwork in terms of what we've seen in terms of the state of the economy, the impact of COVID, inflation, and how that's impacting the workforce population. So I'd like to now provide a little bit of insight about how these factors have impacted the current immigration landscape and how to navigate it during this upcoming H-1B CAP season. So for all of us working in the global mobility space and the talent acquisition space, you may have noticed that what we call the Great Resignation appears to be slowing down a little bit. So we're noticing a decrease in turnover where individuals may be completely leaving the industry, but instead what we're seeing in its place is what we've seen called the Great Reshuffle. The Great Reshuffle refers to the concept that workers are not leaving the market entirely, but instead are jumping from company to company. So what do we expect to see in light of the Great Reshuffle during this CAP season? Well, the employment landscape is still showing that there's very much an increased competition for scarce labor resources and high-skilled talent, as we've seen in the last few years. So hiring is definitely booming. And because of these labor shortages, you should continue to expect candidates to receive multiple competitive offers. So on our end, and maybe this is something that you're seeing on your end as well, when we assess the viability for candidates, potential new employees to join a company and become new hires, we're already seeing an uptick in the number of questions that the candidate is asking about the level of immigration support the company is willing to provide. So therefore, it's very important for the company to assess the benefits you're offering to potential employees and ask yourself a couple of questions. What incentives are the company providing to its candidates? How attractive is your sponsorship model compared to other companies? How can your company better support the foreign national population? So companies should always be looking at their internal immigration policies, certainly talking to us for benchmarking and data so that you can maintain a competitive edge in this marketplace. So in terms of benefits, what are we seeing that companies are honing in on in terms of the type of level of support that they can provide new hires? In particular, we're seeing increased and enhanced support for green card sponsorship, dependent family member support. We're seeing onboarding bonuses as an incentive to join, and an examination to see if there are other areas where the company can support the foreign national population to make that initial offer more attractive. So this could even be conversations up front about covering, for example, spousal work authorization once the employee is legally eligible. So generally speaking, what we're seeing is that the labor market is very short on top talent, and this in tandem with the foreign national population being very anxious and worried about their ability to live and work in the US long term, means that you need to set clear expectations and need to be very clear in terms of the robust immigration support that the company is willing to provide in order to lock in those desired candidates. So we can go to the next slide. Okay, this is our first polling question of the day. When do you start CAP planning? So is it A, before December, meaning you may have already started perhaps a few weeks ago or even a few months ago for the ambitious few, or are planning to start in the next several weeks? B, December, or do you wait after the holidays? C, January, or D, February? So while we're waiting for everyone to vote and we have the poll results, there are couple different factors that come into play when making this type of decision about timing, right? So it's going to be company specific, and perhaps you manage a team that has a very large foreign national population. We certainly have clients, right, where the population is enormous, right? So you want to start planning, start planning now, but it may already feel like your last CAP season just ended, right? Particularly if you're seeing a lot of RFEs that you've responded to and you're just seeing those approvals coming through now. You may also be a company that has a smaller group of candidates and you can quickly put together an action plan for CAP season. So right now it may feel premature. Or you may be somewhere in the middle where you are very savvy, you've done CAP season many years, and it's not your first time at the rodeo, right? So you kind of have a good handle of it, you're comfortable, you're confident, and that is going to decide when you're going to start. So we do have our results here. We have 51% say before December, 29% at December, 18% in January, and 2% in February. So not too many people living on the edge, which we like. We like planning ahead of time. So now we have the results of that poll. I'm going to flip it over to Stephanie, who's going to provide us some information in terms of CAP volume and timelines.
Thanks so much, Heather. So for the next portion, we want to talk a little bit about what we've been seeing over the course of the past several years, both in terms of timelines, volumes, and what does that really mean for what we've learned and where we may be going this year. So we're going to be going into our 4th year of electronic registration, which is really exciting. Things seem to be somewhat evening out in terms of timelines, processes, the first year that electronic registration was in place was for the fiscal year of 2021. That year was a really tough one. Things were really delayed. We weren't sure what the systems were going to look like till the very last day. Fiscal year 2022, things started to normalize. So employers, petitioners, were able to begin creating their online accounts for the electronic registration system around March 2nd. This didn't really provide a huge amount of buffer time because the actual registrations began on March 9th. So during that week, there were a lot of phone calls. What should those systems look like? Who should be signing up? Was everything verified correctly? From March 19th through March 25th is when the actual online registration of H-1B petitions was happening. And then, of course, April 1st was our very first day to begin submitting petitions in the fiscal year of 2022. Fiscal year 2023, we learned a little bit about that online registration in terms of the petitioners being able to create their online accounts. So petitioners were actually able to start doing that as early as February 21st, which was incredibly helpful. That registration period also happened just a little bit earlier. It happened from March 1st to March 18th. That was great. But of course, if you're the kind of employer who is allowing people to accept offers until the very last day and be submitted towards the cap, that meant that your timelines had to shift forward just a little bit more. The final cutoff for being able to submit somebody into that lottery was March 18th. But once again, April 1st was when we were able to start actually submitting petitions into that had been selected. Now, one thing that did remain steady throughout both years, though, was that in both years, we began getting the actual selections on March 26th. That gives us a very small number of days from March 26th until April 1st when we can start actually submitting the petitions to USCIS. A little bit later, we're going to be talking about what that means. Are there any risks or benefits to actually submitting a petition earlier within that window versus later? Now, as much as the actual registration system started to normalize between 22 and 23, what we actually saw was a huge jump in the number of individuals that were submitted into the H-1B cap registration. So in the fiscal year 2022, there were about 308,000 lottery submissions. But in fiscal year 2023, that number jumped all the way up to 483,000. Now, there were a lot of factors that went into that. Heather spoke earlier about the Great Resignation or the Great Reshuffling. And so what we saw was that a lot of employers were submitting more H-1B lottery registrations because of all that additional hiring that they were going through within their businesses. But what was particularly interesting between 22 and 23 was that the raw number of master's registrations actually remained fairly stable. So as you may know, there are actually two different parts of the lottery that happened. There are 65,000 H-1Bs that go out into the general lottery, but then there's an additional 20,000 H-1Bs that are reserved to individuals with U.S. master's degrees. A number of years ago, the way those lotteries are run happened a little bit differently. Now, everybody who's in the master's, everybody who has a U.S. master's degree gets run in the first lottery for those slots of 20,000. After that, anybody who wasn't chosen in that first lottery is placed into the general pool. And then an additional approximately 65,000 are selected from there. One of the interesting things that happens, though, is that USCIS has the ability to select more than just a pure 85,000. They're meant to use information that they've gathered over the past few years in order to identify a larger number beyond that 85,000 to actually select and have petitions filed, because they assume that a certain number of petitioners won't actually file those H-1Bs. So what was really interesting when we really took a step back and looked at this is that despite the fact that master's registrations were only 31% of the fiscal year 23 lottery registrations, the number from 22 to 23 remained about stable, around 150,000. In fiscal year 2021, the number was just a little bit smaller at 125,000, which means that in fiscal year 2023, there were a lot more lottery registrations for individuals who did not have a US master's degree. But of course, there's one more thing about the lottery that we haven't actually talked about yet. How many lotteries will there actually be? For any of you who were part of this process in the fiscal year of 2022, you might remember not one, not two, but 3 different lotteries that were run. That was really difficult. No one knew how many lotteries were going to happen, when they were going to happen, or what they were going to end up looking like. And so like I mentioned earlier, USCIS has the ability USCIS has the ability to run random lotteries in order to predict the number of registrations that need to be selected to meet the caps. So in fiscal year 2022, there were many different factors that actually led into those 3 different lotteries. The first was petitioners that were not actually filing the petitions for beneficiaries who were selected. The second factor was multiple petitioners for each beneficiary, meaning different companies, the same individual might be getting offers from 2 different companies and allow both of those companies to submit registrations on their behalf. A third factor are beneficiaries who had left the company before the actual lottery registration was selected. And then finally, a beneficiary who actually departs the United States and no longer needs that H-1B. However, we learned a lot in the fiscal year of 2022, or rather USCIS learned a lot in fiscal year 2022. And so fiscal year 2023, there was only that one lottery where they selected 127,600 registrations in order to meet that 85,000 petition cap.
All right, thanks, Stephanie. We are now going to roll into our second polling question. The prior question that Heather asked was around timelines in terms of when do you start getting ready. This question is more related to how much of your cases do you prepare in advance? For purposes of this question, we're going to set aside the at-risk or last chance population, and we're really going to focus on the rest of the population. So for those applicants that aren't employees that aren't at risk, how does your company prepare those petitions? Do you A, prepare full petitions for all candidates you register for? B, do you partially prepare those for those candidates you register for? Maybe you do LCAs or something along those lines. Or C, do you wait until after the lottery has been conducted and only prepare petitions for individuals selected in the registration? And while we wait for those answers, I just want to point out that much like Heather, you referenced living on the edge. And I think that sometimes these benchmarking questions are good. From an attorney perspective, I always like to hear the benchmarking. Makes me freak out a little bit sometimes if I'm one of those living on the edge. So I like that. It just kind of gives everyone an opportunity to see where they're at. I also want to point out, going back to Stephanie's comments, for those in the audience, if you haven't figured it out yet, if you are someone who really geeks out over the math behind immigration, Stephanie is your person. She got super excited as we were preparing to be able to talk about all of the numbers. So. All right, so it looks like more than half of you are C, waiting for the lottery results to prepare for this, to prepare petitions and only do it for those selected. That comes in at 51%. 16% of you are preparing full petitions for all, and B, 33% of you are partially preparing petitions. All right, so we'll move on to talk about some different strategies. So Heather, you and I should talk through some of the things that drive a program's decision-making. Thinking back, looking back at the poll, talking about different levels of preparation, can you comment a little bit on when petitions should be prepared?
Sure. So whether your program decides to fully prepare a petition or partially prepare it, as I requested in the poll, kind of depends on the overall guiding principles of your company and your immigration program as a whole, right? So on one end of the spectrum, we see some employers are very, very focused on the employee experience, right? The no cost is too high model, everything is supported from day one. This model really focuses on the candidates and employees having the best experience possible. And these employers will support preparing the entire petition upfront, right? The benefits here are that candidates and employees' anxieties are eased, they feel fully supported, they know that we're all aligned that to file the petition as quickly as possible on April 1st, if we can. The legal analysis of the entire case has been done, right? And issues like wage issues, whether the degree relates to the role, all of that has been vetted upfront. But of course, you can only do this, it's only sustainable if the employee and candidate population is manageable, whatever that may mean for your company, right? On the other end of the spectrum, we do see that companies are more mindful of cost and resources. So whether they are a company that runs lean generally, or they're afraid of a recession, or there was restructuring, right? Those companies may want to wait until registration is complete before completely preparing the petition overall. So typically, and I think the polling question reflects this, is that we'll see that companies will fall somewhere in between in terms of the timeline. So that is sort of the partial prep approach, right? So once we know that an individual's H-1B has been chosen in the lottery, in the registration, there's a 3-month period of time where we can file, and the majority of cases can be prepped and filed during that time. So that being said, we certainly don't want to be discovering legal issues, right? A couple months in when we suddenly feel like, oh, we can't file anymore. So the best practice is at the very least to come up with a strategy, have some legal analysis conducted upfront on each case, and then just begin gathering documentation and information. And then move forward at least with preparing that labor condition application, that LCA, which can be submitted to the Department of Labor, takes 7 to 10 days to be certified. If you at least have that on hand when the registration results are in, then you'll be able to assemble and put together the rest of the H petition. You'll be in a good position to do that.
Thanks, Heather. I agree with a little bit of review upfront, also just in terms of validating whether someone has a qualifying master's degree. So you don't want to register someone in the incorrect category. So always good to take a look at some of those documents up front. I think another group of employees that we want to take a look at and not wait until after registration are the at-risk employees. So can you talk a little bit about some of the different considerations there?
So the at-risk population is one that where we should fully prepare the case no matter what, right? So what is the at-risk population? It's anyone who is at risk of losing work authorization and having to depart the US. So this is primarily the F1 student population. You'll need to take a look to see their work authorization, their employment authorization document, that EAD, to see when that is expiring. If you see that it's expiring before the next fiscal year's cap, April 1st, when we can file again, that means that this is it. This is the last chance. There's no possibility that that employment authorization can be extended. This person must be chosen in the registration and have that H-1B in order to remain in the US and work in the US. So it's very important that your company has good data integrity and works with us. So that we are mindful when we are doing the registrations, when we are sort of triaging on our end, figuring out which cases must be fully prepped, because it's really important that for this population that's very sensitive, we definitely don't want to miss any filings that are critical. And on our end, we also track those work authorization expiration dates as well, because it's going to guide us in terms of letting us know when we can file that CAP petition, because we certainly want to do it before their employment authorization document has expired, to provide them with what's called cap gap, right? Allowing them to work through the summer until October 1st when that H-1B becomes effective. And then so that we can also give good legal advice, accurate legal advice over the summer when everyone seems to be emailing us about summertime travel. So we can let them know who can travel, who can't, and make sure that all of our data on our end is accurate as well.
Exactly. And I'll just reiterate that looking at the status expirations and employment authorization expirations ahead of time is really critical, because particularly if you're a company who doesn't track the dates yourself, or if you have a really high volume immigration program, it's really tough, particularly if you like to live on the edge and not do prep until after the fact. If you have someone whose employment authorization document expires, for example, in April, if you aren't even looking at those documents because of the volume until the end of April or May, they may have missed an opportunity to receive that gap coverage. So really important there.
Mm-hmm.
So that's great. Oh, talk to me a little bit, Heather, about any special considerations for a company's L1 program. Are there any factors to be considered there?
Yeah, that's a great question. There's two factors. One is that you also want to consider, as part of your at-risk population, not just your student, but certain L1 visa holders if they are part of the green card process. So many of you may already know that depending on your country of birth and the type of green card that we are pursuing, the wait for the green card can be 8 years long, 10 years long. So for those individuals who are on the L1 who are nearing their 5th year anniversary, you certainly want to include those individuals so that there's a mechanism to extend the H-1B until receipt of the green card that's not available for the L1 population. So that's first in terms of figuring out whose cases must absolutely be filed this fiscal year if chosen in the registration. Another factor for the L to take into consideration are not everyone can be chosen in the registration, right? There's going to be probably a large group of people who are not going to be chosen. They may need to leave the US, right? And we want to know what the options are, right? What can we do to keep them employed? What can we do to bring them back? The L1 is a great option to do that. So many companies can take a look at the individuals who are at risk, who are not able to get the cap, and see internally, is there a possibility that this employee can be transferred to a related entity outside the US for at least 1 year, and then bring that employee back on the L1, that intracompany transfer. It's not ideal. Obviously, we would want everyone to be able to stay and live here in their current jobs. But if this is an option, a little bit of a silver lining for some folks who are in a managerial role is that we can also explore this EB1 green card category, which has a much shorter lead time than that 8 to 10 years that I had previously mentioned for individuals who are born in India. So that does tend to be a little bit of hopeful good news. But the L1 is definitely a category that you want to consider next for individuals who have not been chosen in the cap.
Great. Thank you very much. All right, Stephanie, let's turn to you and talk about a few additional programmatic concerns that companies may want to consider as part of their cap planning process. I know that you work with a large remote worker population, and that's particularly so during the COVID years. So let's talk a little bit about how remote worker arrangements affect the preparation of labor condition applications.
It's a really great question, Michelle. And I think it's something that many of us didn't really have to consider too much before 2020, but 2020 really changed things for us. A lot of us have gone remote or partially remote. So this really breaks down into a few different pieces. The first is defining what is your remote work arrangement? What does it actually look like? Does your worker work from home full time? Do they work partially in the office, partially at home? Is this allowed or is it required? And the reason this is so important is because as part of your labor condition application, which serves as the foundational basis of your H-1B, you have to identify what the place of employment actually is. So being able to have that conversation with your worker to really understand, where are you today and where are you going to be in October? Because ultimately, one of the facts that plays into this is that if you have somebody who's working from home, they may choose to change where they're living. And if they change where they're living, then they're changing what their place of employment is. So as part of preparing your H-1B cases, it's really important to have conversations with your workers and with their managers, especially if you have the type of arrangement that allows for flexibility where the employee is just letting their manager know where they're going to be working from. You do need to figure out how to exert some sort of control and some way of opening up conversations between your employees and their managers and your HR folks in order to make sure you really understand where it is that people work. So the places that you're going to need to include on your labor condition applications, probably going to be the actual work office that that person is assigned to. It's also going to include their home residence where they currently work. But it could also include other locations. And then the last thing you'll have to take into account is that if you're filing these cases in April, May, or June, you might have to do an additional outreach in August and September to make sure that your worker population hasn't relocated their home, such that you actually have to file an H-1B amendment in order to allow them to work pursuant to that H-1B, again, if they're working from home and they've relocated.
All right, thank you. We've talked a lot about timing today, about when to start planning, when to start case preparation. Is there anything to consider in terms of the timing of actually filing? I know that once the registration results are announced, everyone is anxious to get their petition filed as soon as the filing window opens. But is that possible in all cases?
That's another really great question. So it's important to remember that the requirement is that the individual have received their degree or have completed all requirements for their degree by the end of the filing window, which is June 30th. But you might have some recent graduates, some individuals who you made offers to anticipating that by October 1st they would have their degree, that when we actually submit their registration, they won't have their degrees yet. And so what ends up happening in these situations is that you can submit them either towards their bachelor's cap or into the US master's cap, assuming that they're going to be getting a US master's degree. But we can't actually file their cases until they either have their degree in hand or have some other proof from the university that they've completed all of the requirements for their degrees. So in some cases, that may mean that you're actually submitting people towards the lottery who haven't submitted their degree yet, and they're still crossing their fingers and hoping that they pass all their classes and that they'll actually have their degree in hand come June 30th. So it's not always necessary to file the cases as early as possible. And in many cases, it may not even be possible, because if it is filed before the person has their actual degree, then the case would be denied because they will not have met the requirements as of the date of filing the petition. So that's something that we would work with you on. One of the things that we do when we prepare cases is we ask for all this documentation from foreign nationals. And this is also one of the reasons why sometimes doing partial prep or prep in advance can be really beneficial towards those lotteries. Because sometimes what we see is that foreign nationals will raise their hand and say that, yes, they will have their degrees, or yes, they've completed everything. But when we actually get a chance to look at their documents, we realize that they actually might not. We actually have cases sometimes where somebody thinks they're going to be graduating from their master's program in May, but then it turns out that for some reason or another, they deferred a credit, and now they're not actually graduating and finishing their course requirements until December of that same year. That type of situation where you have somebody who thinks they're going to graduate in May, but they actually have to wait until December because they didn't finish everything, that person would not be eligible towards that lottery if they were to actually file their H-1B case, even if they were selected in the lottery, if they don't have the relevant degree.
Got it. Thank you. One last program consideration we want to talk about today. Heather previously talked a little bit about L1 options, but if your candidate or your employee is not selected in the lottery, Are there any other backup or alternative options you can consider?
This is a great question, and this is like the great puzzle that all immigration lawyers love to engage in come in these days come April, right? Once we actually know who was selected and who wasn't. So the different categories that you can consider really break down into what we call your nationality-based categories, and then a couple of others. So depending on the nationalities of the individuals that you're sponsoring, they may have certain types of visas available to them that are only due to certain treaties that exist with countries that they're citizens of. So the most popular ones that we see are TNs. Those are individuals who have nationality in Canada or Mexico. Interestingly, it's not about where the person is born. So often what we'll see is an individual who might be born in a country like China or India. They will go set up a life in Canada. They will get their citizenship from Canada, and that will actually allow them to eventually come to the United States and get a TN visa, which they wouldn't be able to get otherwise. Another alternative is the E3. The E3 is specifically for nationals of Canada, excuse me, nationals of Australia. And the E3 is a lot like the H-1B. It is a specialty occupation worker visa. So it does actually require a labor condition application. So the E3 kind of looks a lot like the H-1B. The third option is what's called the H-1B1, which is almost exactly like the E3 and the H-1B, but it's reserved for nationals of Singapore and Chile. Outside of those nationality-based categories, what we often see are O1s. Now, O1s are petitions for aliens of extraordinary ability. We often see them in areas like the sciences, individuals who have a PhD level degree, who have publications, who are working in research-based positions. So that's a very popular immigration category, specifically for those individuals with very high level of knowledge. But we also see it sometimes from individuals who might be, for example, L1s who have been here for a very long time, L1Bs who maybe were with your company for a long time abroad, have a significant base of knowledge. Maybe they have a lot of contributions that they've made to you and the company. So those are the really popular ones. There are some other ones out there, but that covers most of what we look at.
Excellent. Thank you. All right. So overall, notwithstanding the challenges from the pandemic or the economy, the H-1B CAP process continues to be vital for the workforce of many of the companies we work with. As employees continue to be mobile and look for new opportunities, it's important for employers to remain competitive in terms of sponsorship and benefits. In terms of setting expectations, it's also important to remember that the fact that someone is selected in the registration process does not guarantee smooth sailing. We continue to see RFEs, we continue to see delays at the consulates, and Stephanie, Heather, and I could spend another few hours talking about just those two issues. Even if you've handled a CAP season a number of times, either in-house or with a law firm, it's really important to think about how you are setting up your program, setting up your filing strategies, and anticipating challenges along the way. So we hope that some of the information that we've brought to you today has been helpful, and we will open it up now, I think, for some questions. All right. Heather, let's kick it over to you. We have some questions that have started to come in. What should companies consider when determining who will get sponsored for an H-1B CAP season?
This is a good question. So as we previously discussed, the at-risk population, definitely, right? People who will not have another chance at that apple. You may have heard that A lot of you may have heard that phrase. It's sort of the last chance to get an H, or you need to leave the US. And then after that, you want to take a look at your employee population and consider what is the underlying status, right? And what's the company's sort of long-term plans for this employee? So depending on how hard it is to hire and retain someone for this position, or maybe you have someone who's an outstanding performer, right? All of these factors are going to take you into consideration in terms of, do we want this person to be employed in the US for this company in the long term, right? If that's the case, you want to take a look to see what if the underlying status has a limit, like the L-1B, for example, is only 5 years, right? Then you'll need to kind of kickstart that green card sponsorship process and the CAP H-1B process in tandem to be able to keep that employee here beyond that 5 years, right? But if the employee is on a non-immigrant status where you can potentially extend it or renew it indefinitely, right? The TNs, the E2s, then those decisions are not as time critical. So you can sort of assess based on the employee's performance and the business need when you want to include that person in the CAP.
All right. Stephanie, I think this question goes back to the full prep, partial prep, no prep question. Other than the considerations that we talked about, are there any other benefits of preparing a petition fully in advance? Setting aside, again, the at-risk folks, but for everyone else, are there any benefits to preparing the petition in advance?
So I think this really comes down to your specific program and its size. I like how Heather specifically called out that depending on how big your program is, doing full prep in advance might not really be a workable solution. However, we have actually seen some cases with smaller programs where even because they did full prep from the outset, the cases were ready to go as soon as the selections came through. And so what we saw with those cases is that we were able to file them on or about April 1st, which resulted in them being processed in just a couple weeks, even without premium processing. So there definitely does seem to be some benefit to kind of getting in ahead of the wire and ahead of everybody else who's not doing any full prep in advance, in terms of being able to save by not having to pay for those premium processing fees, which more than doubled over the course of the last 2 years.
That's a good call out. Speaking of levels of preparation, we sort of laid the poll out as all of one or the other. What do you all think about a hybrid of preparation? So doing full prep for some, no prep for others. Do you all see that in your programs?
Absolutely.
Yeah, okay, go ahead.
Yeah, I think that's probably one of the most popular approaches, right? Do full prep for your whole at-risk population and file those with premium processing. That way you know as early as possible what's going on with that H-1B. Nobody likes to see H-1Bs denied that are selected in the lottery, but unfortunately it does happen. So having those ready to go can achieve two different things. First of all, you're going to have your cap gappers, so individuals whose OPT work authorization expires before that June 30th date, right? And in order to allow them to basically have that bridge between the end of their OPT period and their H-1B, you're going to need to get that petition into USCIS before their OPT expires. So even though that window in theory is April 1st until June 30th, if you have somebody whose OPT expires on April 5th, you have to get that in there before April 5th. So that's the first set of people that you definitely need to do full prep for. But then you've got your other folks, maybe the individuals who have something challenging about their immigration situation. They're going to be maxing out. Maybe they have a tricky case. Maybe they're an individual who has a lot of experience, but their degree is kind of in a weird field. We wouldn't even know about that unless we did some amount of partial prep in the beginning usually. But that's really where the benefits of doing that hybrid of some prep in advance, but then everybody else you can do later once you actually have the selections. Heather, do you have a different approach or other factors that you would usually consider?
No, I would mirror what you said exactly. We want to at least have some level of legal analysis done up front if possible, so that we're comfortable, even if we're saying that we're partially prepping, we have the LCA, and we're going to assemble and put together the petition later down the line. We're at least comfortable now that every case has been vetted on our end, so we don't get those surprises down the line. Because there is absolutely nothing worse than having a plan to file, everyone is on board, and then all of a sudden at the last minute, something comes up, right? And there's always a question of why didn't we catch this beforehand? And a lot of that has to do with what the volume of the program is, right? And what I said before was what's manageable for the program. But at the very least, we want to make sure that we're vetting every single person and having some of that preliminary information and documents up front, even if we're actually not preparing everything fully.
Great. All right, a few questions have come in around premium processing. Which, Stephanie, as you mentioned, the cost for that has gone up considerably. So the first thing is looking into your crystal ball. Can we ever predict, or what are your thoughts on the availability of premium processing throughout any given CAP season? And either of you is welcome to take that one.
I'll look into my crystal ball. So historically, what we've seen is that when we saw premium processing put on hold, that was actually in the pre-registration years. And that seems to have come from the fact that USCIS had to intake all of these petitions, had to give them numbers, had to send them out. And so that created a really significant administrative burden for USCIS. It has seen that ever since the introduction of electronic registration, especially because they don't have to accept, they're not going to get all of the cases on the exact same day because they have that 90-day window. It seems far more likely that premium processing will remain in place, but don't quote me on that because USCIS could change that at any time.
Perfect. And it feels like we should have had another polling question along the lines of, assuming it's available, does the company pay for it? And I would say from my perspective, it really runs the gamut. I have some companies that hold fast and say, let's just file regular and see what happens. Some that file across the board, and then some that say we'll do it on an as needed basis. So maybe we'll file premium processing for the at-risk population and not for anyone else. And so I don't know if you all are seeing anything different, but I think it really kind of varies on sometimes the size of the company, the number of petitions they're filing, and really what the particular needs of the program are. Yeah, okay. Heather, do you see a lot of companies apply for H-1Bs versus L-1s for employees hired outside the United States?
Yeah, this is an interesting question because I think when we think about CAP planning, the majority are students, right, who are already in the US, and we're trying to keep them here. But there is also a subset of candidates that are outside the US, and we're trying to figure out how to get them here to the US. The first thing we consider is always the L1 intra-company visa first, right? Because the person has to be eligible. So not everyone hired outside the US that we want to bring in is going to be eligible for that L1. We need to make sure that they have that 1 year of employment at an entity connected to the company outside the US. If that's the case, we'll pursue the L1 first, have them come in, and then have conversations later on if we need to pivot to the H-1B, what are the benefits? We've talked a little bit about that green card process, depending on what country they're from. And those conversations can kind of be done after the person has come in on the L1, they've started employment, right? Because that's usually the time critical piece. In terms of considering CAP for an H-1B, we certainly can, although I don't see that as much. And the reason is because there are a lot more hoops, right? You need to do the registration, you need to see if the person was chosen, then you need to do the filing. And usually when a company wants to bring someone in from outside the US and they're hiring outside the US, it's because the role is very hard to fill, right? So if the L1 is an option, we always do that first because it's sort of the faster route. The individual is still going to need to get a visa stamp before coming to the US. And we know that for particularly countries like India, the appointment dates are very scarce because of the labor shortages there too, as well as the backlogs from COVID. But because we already have all of these sort of systematic delays in place, we don't see the H-1B for caps that much for new employees hired outside the US, because we don't want to have to wait to see the registration, the filing, and then to have to get that visa appointment from outside the US.
Perfect. I'm tagging you, Heather, with this one because you're emerging as the person answering the L questions. So assuming you have an employee who's in the US and their L1 expires September 15th, but they're selected in the lottery, is it okay to do a change of status? Can you talk a little bit about status up until September 30th and how that works with change of status versus consular petitions?
Yeah, so it's important to note that when we do the change of status for a CAP case, it's effective October 1st. So when we're filing these change of status petitions, you really want to be mindful of when the expiration date is, so that you can make sure that while the petition is pending, you can remain in the US. But if it happens to be approved and the effective date is October 1st, and you have someone who's already expiring September 15th, right? You want to make sure that there's some way to be able to bridge that gap. Without them having to leave the US. Perhaps there are options. Perhaps some people are lucky enough where their spouse is also on an H-1B and they're eligible to get that H-4 EAD, right? But these are certain things that you want to take into consideration.
Excellent. All right, Stephanie, over to you. When you're in the process of preparing LCAs, would you have the employee post the notice at their home or just at the company office as part of this process?
This is one of my favorite questions, because nothing is funnier than envisioning a foreign national putting a copy of their LCA up on their refrigerator and then on the inside of their front door. So what we usually tell employers that have a large remote worker population is that it would probably be a good thing to start thinking about taking your LCA postings and making sure it's electronic, so that what you're doing is you're actually making them accessible to all workers of your company, regardless of whether they're based in the exact same office. So short answer, yes, you can ask them to post it on the refrigerator, but then you're going to need to get copies of those back and proof of those postings. But you can also move in the direction of electronic posting of LCAs, which is going to be much easier for you to manage.
All right. Earlier, we talked about multiple job offers. Are there any restrictions against two different employers submitting the same person in the lottery?
Another really good question, Michelle. And so the answer is it depends, right? If there are two completely different, unrelated companies and they're two completely unique job offers, no problem. So your foreign national employee might go get two different job offers, one from you and one from a competitor, and be submitted into the lottery twice in order to increase their likelihood of being selected. That's totally fine. But what's not fine is creating two different job offers with related companies and essentially what the government calls colluding to increase the likelihood of your worker being selected by essentially submitting two different registrations for them for the same position, but under different company names.
Got it. Okay. Heather, does it bring up any red flags if an employee is not chosen in the lottery and is transferred to Canada? Can you talk a little bit about employees being transferred abroad if their petition isn't selected?
Sure. This is a very specific question for Canada. So the short answer is no, there are no red flags. And this is part of the contingency planning that we do with all of our clients, right? So there are going to be people who are not selected in the registration, and we unfortunately need to have these kinds of conversations to figure out how can we keep employees with this company and bring them back into the US in some sort of work authorized capacity if there's no change of status available right now through other means, right? So we do see companies transferring their employees to other entities outside the US. It could be in their home country, wherever it may be. Canada is a popular one because it is very close. There is no cap. There is no sort of USCIS isn't taking account of who's going where, right? If you're not chosen the cap, they're not asking to see, well, what happened to all of these people who actually weren't selected in the cap, right? I would say that if you're planning on transferring your employees, to another country, the biggest thing to keep in mind is to make sure that that person has work authorization in that country, and whether that person needs to have a visa to enter that country as well. So for home country, right, those are easy questions, right? Home country, the person can work, the person can travel there. But if you're planning on transferring the employee to someplace closer to where they need them to be, whether it's Canada or the Caribbean, we see less often, right? But someplace that's closer, you definitely want to take into consideration what are the other legal requirements there.
That's a great point. The other thing I would add is that if you're listening in-house and you don't sit with your HR team, it is important, even when the person is going back to their home country. Sometimes some companies have policies regarding maintaining open offers in the United States and what it looks like for someone who is a permanent US employee versus someone who's here on assignment. And so all of those things, I think, go back to doing that at-risk planning for those employees so that you can make sure that if they aren't selected, you're not scrambling at the last minute to find continued work authorization for them, whether it's in their home country or in another country. I think we'll go with one last quick question, which is, for purposes of premium processing, is there any impact if you're talking about a consular petition versus a change of status petition?
So the short answer here is no. The premium processing timelines are going to be the same regardless of whether you're selecting a change of status or a consular approval for your case. Of course, that requires the USCIS to accept premium processing for both of those case types. But assuming premium processing is available, then that usual 15 calendar day window for premium processing of H-1Bs would be the same.
All right, thank you. Well, on behalf of the three of us, thank you so much for joining us today and giving us a chance to talk about one of our favorite topics. We've really enjoyed it, and thank you again so much.
Michelle, Heather, and Stephanie, thank you all so much for the wonderful insight as usual. And for the rest of you, thank you for attending. If you're seeking PDCs in conjunction with this webinar, please see the appropriate activity and seminar IDs on this slide. To note, for SHRM PDCs, a certificate of participation will be awarded after the completion of the feedback survey. And finally, thank you for joining us for today's webinar. As a final reminder, we would appreciate your feedback via the survey section at the right of your screen. Your feedback helps us shape our future webinars. Be sure to watch your email for a link to the on-demand recording and PDF presentation. Thank you again, and have a great day.